I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today we will be jumping into compilation 108. It will feature 4 different judges. Before I give you the names of those judges, I just want to say thank you, as always, for everything that you do here to make the channel successful, whether that's watching, commenting, subscribing, liking, sharing, whatever it is that you're doing, whatever role that you're playing. I just want to say thank you. And also, I want to put out there, if you guys run into any sovereign citizen proceedings that we have not posted here on the channel and you have access to and you want to send it to us, by all means do so. You can find our email in the channel description, or as you go to our channel, you'll find the email there where you can just email us any of those videos, and we'll be glad to share them here on the channel, because I'm sure if you're interested in it, somebody else would be as well. Now, let me give you the rundown on those judges, but remember, there will be no commentary added to the end of this, and also chapters will be added for your convenience. The first judge courtroom that we will be in will be that of Judge Jeff Cahn out of the state of Colorado. Second, we will be in the courtroom of Judge Victoria Shackleford out of the state of Michigan. Second, we will be in the courtroom of Judge Michael Ciungan out of the state of Michigan. And then third, we will be in the courtroom of Judge Victoria Shackleford, also out of the state of Michigan. And last but not least, we will be in the courtroom of Judge Marena Taylor, also out of the state of Michigan. Guys, these compilations wouldn't be a success without you. So continue up the good work. And like I said, anything you want us to cover, any footage you may have dealing with sovereign citizens in the court or out of the court, just send it to us. We sure would appreciate it. Now, let's go ahead, guys, and jump in 108.
Hi.
Still the same old charming self. Okay, good morning.
I'm really grateful to see you. You don't even, it's been crazy. I've been looking forward to this moment.
I imagine you are. We've been tracking you as to where you've been, so we knew where you were in Jeffco for a while.
Great. Yeah. I was worried. I'm like, why am I not trying? Yeah. Anyways, health. Yeah, I'm grateful to see you guys.
Okay. So
Colleen.
I was able to speak with Mr. Cardona. He is inclined to take the plea. However, before he does that, he wanted me to inquire, since he's been in custody since April 3rd, if he would be getting credit from that date.
So Ms. Talene, the credit that he would get would be for the time that he's been in custody in Boulder, not for the time he's been in Jeffco.
And that's only for a day. I think he's only been here for a day.
So in other words, no.
Okay.
No dice.
So then I think he's probably not going to end up taking that deal. I mean, I will say he still has some other stuff that he's got to figure out. So
I'm time served on the other stuff, because it's since they entered a writ on April 10th. So I'm time served on that. And I'd be willing to negotiate, look, I've been through so much. My mom is stealing my dog, which you guys
are careful with the language. Careful with the language.
You all know that she's mine. And so I had to take a plea, and I'm just so done with all of it. I'm ready to take a plea, whatever. I'm over it. I've just done 122 days of my life for something that I did not do. And so if you guys could help me to help you to help us, I'm definitely down. I'm just not going to sit in here for 45 more days for mostly garbage charges. Like prohibited item. No. I'll bail out and we'll go to trial if we have to, but I would much rather not have to have loose ends, and I would much rather deal with it than have to continue prolonging it. So if we can come to an agreement that's not.
So let me ask.
I can't be part of that discussion. So let's pause.
I was going to say, so let me ask you this, Julio. What if we brought you back next Wednesday and I could speak with Ms. Keller about some different options for you?
That would be great. If in the meantime, as I said, I'm time served on my other ones. And so
you'd be able to bond out still. If you can post your bonds, you'd be able to bond out. But
according to the jail, there's a $50 cash only bond. And since like I was trying to come to court last time, I got arrested 2 days after you signed the release or PR bond on Sunday the 28th. I would have been here, but I got arrested. So if you would be willing to reinstate that PR bond on that, I'd be grateful. I'm still held on a $2,000 bond until I go to court, but I don't want to be stuck in here. If I post a $2,000 one, which I guess, right, if I post a $2,000 one, I don't want to be held here on a $50 more thing. So if you would be willing to redo what you did on Sunday, March 28th by signing a PR bail and reissuing that, I'd be grateful. I would have been there, but I was in jail and I couldn't be there. If you'd be willing to do that, I'd be grateful. If not, I can probably try to come up with a $50 bond that it's currently $50 cash only.
Is that what they're telling you at the jail? Is that that's the only cash bond that you have to post? The others are PR bonds?
No. Well, so originally when I first got here, before I got here, I was told I had 4 $200 cash or surety bails. Meaning the 10 cent, like basically $80. But then I got here and they're now telling me that there's a $150 cash only for my municipal cases, but no PR bonds. So I basically have to post a $2,000 cash or surety bail and then a $50 cash only bail. I do have my family working on the cash or surety $2,000 bail. But that apparently they didn't do the 10% option or whatever, so they can't just go to touchpaydirect.com and do it like they usually would. My mom's obviously doing the other thing, so the only person I have that is family to help is over 10 hours away and not able to be here. So they're trying to do it online and trying to facilitate to that. But even once they accomplish that, then I'd still be held here on the $50 cash only bail until I could come up with that. It's like, so if just originally on March 26th of this year, I took a plea bargain and then I was still held here to come to your court. And then on Sunday, the 28th, I'm assuming it was you, signed the approval for a PR bail in my municipal cases. And I was released on Sunday, the 28th, and I was arrested again on the 3rd. So it wasn't that I was trying. When I'm in cuffs, I can't show up. You know what I mean? I did have my family text Ashley, try to reach out to Ashley and everybody to try to communicate so that you would be aware that I wasn't trying to skip out on you, and that it's been a crazy few months.
Okay, so let me just have you pause for just a moment, Mr. Cardona, because what Fernanda has been doing while you were speaking was getting me copies of the warrants and the bond amounts that are on those warrants from our court. And so I'm going to share what I have. And Fernanda, you can jump in after I've done this. But what I am seeing is in case number 2024-5724, there's a $200 cash bond. In case number 2024-5730, there is a $200 cash bond. In case number 2024-5633, there is a $200 cash bond. And in case number 2023-4906, there is a $200 cash bond. Now, I don't know. I would have to do a little bit more digging because I'm just looking at the face of these bonds. They don't show the charges, so I'd have to go into each one to see if they were eligible for PR. I know that 2023-4906 is not eligible for a PR bond. That's one of the $200 cash bonds. And at this juncture, not today, I'm not willing to convert those to PR bonds. They would maintain those. That one is a cash bond. By statute, there are some that have to be converted to PR bonds when a defendant requests that. So I will be looking at each of those to make sure that I'm complying with the statute, because what defendant has done now is made a formal request for a PR bond. But I know 2023-4906 has a misdemeanor state counterpart, and that one would remain. So we can do this now, or what we can do is hold off, like Ms. Talene was saying, and come back on Wednesday. And in the
then I
meantime,
might be able to talk to Miss Keller and see if we could work out some disposition. I don't know. We may or may not, and then we could deal with the bonds as well. But
Okay. Even if we could get them to convert it to the cash or surety 10% thing, I'd be willing to post a bond. I have no problem trying to
so that
post it.
maybe that's what you're thinking, because our cash bonds also come with an alternative of a surety bond. The surety bond is 500. So maybe what you're thinking is that you have to pay 50
with the
to a
50,
surety, and
yeah.
then that's your 10%. But
Yeah.
our cash bond right now is 200. A surety bond would be 500 on that case. So that's why you might be thinking all you have to do is come up with 50 to get a surety to do it. But that's not something that I have control over. That's obviously between you and a surety, a bonds person. So
Whatever happened to the 10% thing that you guys used to do, to where my dad could just jump on the...
that's not us. That's what I'm saying. That's something that's done with a bonds person. And there may be something where there's an online process. Ms. Talene may know more about that than I do. I've never interacted with the online bond posting process with a surety, but that's a separate person who's doing that, or a company that's giving you, posting the bond on your behalf based on your dad or you giving them a certain percentage of the amount that's owed, and then them being responsible for the rest. That's how the surety bond works. Does that make sense to you, Mr. Cardona?
Yeah, I'm just trying to, because every other time I've bonded out on every single case you're talking about right now, including the one that you say is not PRable, and I've been released on that charge on PR several times. So I'm just confused as to why it's suddenly different.
Well, right now you have a cash bond that I've imposed, and it's because there's been failures to appear. Obviously, that's why I've made it a cash bond and am not converting it to a PR bond. I am going to follow the state law with respect to the ones that you're entitled to have PR bonds, and some charges you are automatic PR bonds. The more serious ones are not. The ones that are less serious, like you mentioned, a tent or a camping charge, those are automatically eligible for PR bond. That's probably why what you remember most is most of your cases have been eligible for PR bonds, because they were automatically eligible for some.
So I mean, like, you released me on those charges, even the ones that you say. And again, it wasn't that I didn't appear, it's that I was being held against my will in another county's jail. So if you could reconsider that, I'd be grateful, because this
I will. I'm not going to reconsider it today, because I don't think any party has the opportunity to go through all of the circumstances of each of these. And given that Ms. Talene is in the mindset to see you Wednesday, and that you have another case that's pending with the bond for this state, let's reset your case. I'm happy to reset it. And we could even do Monday if you think that's better, Ms. Talene.
Well, the only reason that I was asking for not Monday is just because it's Friday and I'm actually getting on an airplane in a couple of hours. Okay. So, I mean, I'm doing court on Monday, but I'm just saying I don't know if I'm going to have time to actually talk with Miss Keller and look up all the bonds and all of that information by Monday. So that's why I was asking for Wednesday.
If everybody wants to remain on, I'll pause and I'll look through every single one of these cases to see which ones are eligible, but it may take me quite a bit of time to do that.
I would be grateful, but
I mean, I guess we could bring it back on Monday and I can see what I can do by then. And if I don't have a chance to talk to Miss Keller, it is what it is. Or you can do it now. I mean, either way, I'll defer to the court.
All right. Let me someone was trying to speak. Who was that? Was it Miss Keller or Miss Fernanda?
Excuse me, Your Honor, it was me, Ms. Bittencourt. Mr. Cardona does have a court appearance with Boulder County on the 13th of August. So I believe he's still being held until then.
Right, but I have the bail for that. I'm going to post bail on that, and or also that court date on the 13th. I'm already time served already, according to the deal that they're going to do on the 13th.
Let's pause and then I'm going to look through the files, see what I have here. And then it may take me a few minutes, because I got to look through each one of them and see which ones are automatic PR bonds and then which ones are not.
I know there's a lot. Thank you very much for working with me, guys.
Okay, I'm going off camera for a moment.
Oh my goodness. Oh, it's still waiting. They're going to come back. Appreciate you. He said it might take a while because I got like 21 cases he's got to go look at. So.
I have a quick question for Fernanda. Fernanda, the documents that you provided me, are those the only cases where we've issued warrants?
There's one more case, Judge. I can say it to you. Let me know when you're ready.
Go ahead.
235211GE.
Okay.
That warrant hasn't been cleared yet. The other ones Jefferson County cleared for us.
Okay, thank you for that. I'll look at all. So I think it's really 5 cases that I have to look at then.
That is correct.
Okay, I'll be right back.
I don't know if everybody can still hear me or not, but one thing that I know that I've become aware of that I wasn't prior is 90% of these charges are what's called administrative legislative statutes, which is known as color of the law, and that is illegal to practice. And if it continues forward, I will be giving statutory official notice to everybody of the 1983 federal lawsuit that I will be bringing into the court. If this court does continue forward under administrative legislative statutes without an verified injured party and under their assumed jurisdiction, I will be suing. And I will give everybody statutory notice of intent to sue both individually and to official capacity as soon as I get out. Or we could just settle it. Seems like it'd be a lot easier for everybody. There must be a verified injured party, and you must prove your jurisdictional means to do these things, none of which have occurred. I am hereby asserting my rights to those things, assuming that everybody can hear me. It's being recorded, so it's on record regardless. Yeah, it's still going. I'm still waiting. I'll let you know when I'm done. Hey.
Okay, we can go back on the record. And I did hear what defendant had to say with respect to his statutory rights that he believes he has. I'm not going to address those issues with him. That's certainly his right, and he can consult with his own attorney as to how he wants to proceed with respect to that. I'm just here to at this point to address the request for PR bonds. There are many cases for which we have not issued warrants at all. Okay. And then there are 5 cases for which warrants were issued, 4 of which were cleared by the Jefferson County Jail. 1, for whatever reason, hasn't yet been cleared, but it will be cleared. Of those 5 cases, case number 2023-4906 is the most serious. It's a threatening bodily injury charge. That has a $200 cash bond or a $500 surety bond currently authorized. It does have a state counterpart. I did note that the defendant had failed to appear more than once. Many times he would call after court and get his case rescheduled, but there were 2 separate failures to appear in that particular case. And one, the most recent, was March 11th of 2025. And then ultimately we allowed PR bonds on those, I believe. But in this case, now that there are cash or surety bonds in place, I'm going to maintain that cash or surety bond on case number 2023-4906. Case number 2024-5724 is an obstructing government operations charge. There's a prohibited items. That's PR bond, but the obstructive government operations is not a mandatory PR bond because it does have a misdemeanor state counterpart. That will remain at a $200 cash bond or a $500 cash or surety bond. Case number 2024-5633. This is an improper care of animals charge, which does have a misdemeanor state counterpart. That will remain at a $200 cash or $500 surety bond. Case number 2024-5730 is an obstructing government operations charge. That will does have a misdemeanor state counterpart. That will remain a $200 cash bond or $500 surety bond. And then case number 2023-5211 is an obstructing government operations charge, which is has a misdemeanor state counterpart. That will remain as a $200 cash bond or $500 surety bond. All the other cases we have not issued warrants for, so that I'm not issuing warrants on those at all. If in fact you are released from custody on posting bonds, those cases will remain active and you can come to court on those. But I'm not going to issue warrants because I don't need to unnecessarily burden the system with warrants.
Just as these ones currently are, because I was in custody when you issued the warrants.
That's not actually true. You were not in custody on March 11th. I issued those warrants, those cash or surety bond warrants on March 11th.
Then why would you release me on March 28th?
You were ultimately released I think you were taken, not released, but taken to Jefferson County.
No, I was released. I was released.
Okay, then if you were released, then you were released on some kind of bond that you
posted. I was
posted,
released
right?
on a PR bail on these charges, which is why I was asking you to please redo that, because the only reason I didn't show up was because I got arrested by Glenwood Springs or Garfield County and then transported to Jefferson County. It seems I was in custody by another jail after being released on PR bond on all these same ones. And
I hear what you are. I hear what you are arguing. It is not. It's incumbent on the defendant to appear in court on their court date. There can be all kinds of explanations for why someone doesn't appear, but it's not the court's responsibility to simply say, well, because you got arrested by another jurisdiction, you're exempt from having to appear in our court. You had an obligation to appear and you did not appear.
I tried to. They wouldn't bring me. There's nothing I can do about that.
Right. Well, right now, I'm maintaining those cash bonds in place. There won't be any other warrants issued on the other cases.
Okay, well, I'm going to go, and I don't mean to interrupt you, sir, but I have to. I'm going to just go ahead and say right now here on record, I'm appearing especially, not generally, and without a verified injured party and without proof of your assumed jurisdiction under administrative legislative statutes and or color of the law, you are violating my constitutional rights according to 42 U.S.C. 1983. And if you do not dismiss this case and you continue forward, I will be suing all of you in individual and official capacity for violation and knowingly depriving me of my constitutional rights under the color of the law.
Okay.
If you want to settle it, I'm down to settle it. I'm not.
You can't talk to me about settlement with me present. You can talk to the prosecutor with your lawyer present for that, but I can't negotiate with you because I'm not on the other side of the case. That's between you and the prosecution.
You are the judge, though, and you do have the jurisdictional ability and legislative power to dismiss this before getting sued under 42 U.S.C. 1983, which is I'm
not dismissing it, nor do I believe I actually have the authority to dismiss the case where there's probable cause for the charge.
All right.
So, the authority to request dismissal comes from the prosecutor's office. Now, let's talk about procedural posture where we're at today. So, Ms. Talene, do you want to come back on Monday or do you want to come back on Wednesday? We can do it either way. It's up to you.
Mr. Cardona, what do you want to do?
I mean, Monday would obviously be the best. I'm also going to contact my other attorney, which is Catherine Spangler, to get the other court date moved up. I'm time served on the other one. I would be time served on this, or you guys can all get sued. I don't really care. But I would prefer Monday. That would be the best. But I also want to give you time. And I'm speaking like me. I'm not trying to be a hard ass. I don't care. I've been getting fucked from I've been getting screwed from every angle without just cause. I've learned a lot of my rights and I will be exercising them. But again, I would much rather not deal with the fight, just as I know you would like to not deal with the fight. If we could please come to some form of agreement of time served I've been in jail for 122 days for something I didn't do.
I'm going to pause for now. I'm going to pause now because I think you're having discussions I don't want to hear because I'm not legally allowed to hear them. So if we'll reset, let's reset for Monday.
Yeah, we can reset for Monday. And if I can't do anything on Monday, we'll just reset you again.
Right. So another question I have. So you said they're $500 cash, or if it's a surety, it's $500, right?
That's right.
And so then somebody has to pay a bondsman 10% of that?
That's up to the bonds person. I can't speak for them, but a lot of times they will allow, less than the full amount in order to be responsible for the bond. But that's not something I can commit to.
How many of them? There's 5 of them, or
yes.
Okay, and what were you about to say, Ashley? Sorry.
Yes, usually bondsmen charge 10% of what the bond is.
Okay.
So, but yeah, that again, though, that's not something I can help you with because I'm your attorney. So you got to go through a bondsman.
Right. I'm just trying to make sure I know it, because the jail here, if I posted my $2,000 one and I gave them $50 cash, they would be releasing me. So I'm just letting everybody know that.
Then talk to the jail about that, and if that's what they, if that's satisfies your bond, then I mean, talk to the jail.
Okay, yeah, I just had it written.
Yeah,
I just had it written down about an hour ago. So I just want to make sure that if I go pay these things, that I'm not still right. So I'm just trying to work with everybody and make a winning solution for everybody. All right.
Well, like I said, I mean, talk to the jail. They'll talk to you about how they could potentially get you bonded out. So okay.
And let me just say that one of these bonds, 235211, is a $50 cash bond. So 4 of them are a $300 surety bond. So that one has a different amount on it than the other 4. The other 4 are 200 cash. This one's 50.
Okay. So yeah,
the jail has all of these bonds, so they know what the warrants are and what the bond amounts are. Whatever they determine for you to post to be released, they will do that and accept the payments from you as they deem appropriate, given the documentation that we've given to them.
According to them, less than an hour ago, those 4 $200 ones.
So just go talk to the jail about it then and see what you can do, because they have
shut up, stop.
Yeah.
All right.
They have the well, no, I'm just saying they have the information. There's nothing else that Judge Cahn can do for you. Now it seems like it's going to be between you and the jail and potentially a bondsman.
That's right. Okay. Right. We'll see you.
And we'll see you on Monday. Yeah.
What time do you guys know?
10:30.
Okay. All right. Thank you. Have a great weekend, everybody. And
see you Monday.
Mia, please work with look,
I'll
lady,
I'm
Keller,
not about. Okay, I'll talk to Ms.
done
Keller
resisting.
about it.
Another thing I wanted to say is I've been a difficult prick a little bit in the past. I was going through a lot, and I'm please work with me. And
I will speak with Ms. Keller. Okay.
Okay. Thank you.
All right. Let the officer know that we're ready to go.
Bye, Cahn.
All right. Take care.
You too.
Fernanda, why don't you come on back? We can talk about how we reset all these cases.
Sounds good, Judge.
All right. Good morning. I'm Judge Ciungan. We are here on People of the City of Taylor versus Randall Crane. Good morning. I see Mr. Crane up on screen. Sir, I believe you are muted. If you could unmute, please. There we go. Good morning, sir. Would you state your name, please?
My name is Randall Timothy Crane.
Good morning, Mr. Crane. And on behalf of defendant, today we have, please.
James Kazicki. I'm the House Counsel. I spoke with Mr. Crane. We had a breakdown in communications. I don't believe I can go forward representing him. We do not, support the same theory of law.
Mr. Crane, sir, you do have the right to have a court-appointed attorney. Do you wish to have a court-appointed attorney, or are you going to represent yourself at this time? You could change your mind later on, but at this stage, sir, are you representing yourself?
Sir, me and the House Counsel do not agree on a bunch of things.
I understand that. My question is, all you're here for today is I'm going to actually give you the formal arraignment and conduct a pretrial. All I'm wondering, sir, is are you going to represent yourself at this limited proceeding? That's all, sir.
I I would like to have a assistance.
Okay, all right, but at this time, we do not have other counsel. But what I am going to do is what we call an arraignment. All arraignment, sir, is just a formal reading of the charges that are lodged against you. That's all it is. And I explained that the rights that you have.
Well, I understand my rights.
Hold on just a minute, please. Hold on just a minute. I want to make sure I have the complete file. Mr. Guzicki, maybe you can offer a little assistance, sir. Okay, no, I've got it. So, for the record, Mr. Crane, you're here for an arraignment. As I explained, sir, arraignment is that initial stage of the criminal proceedings, or simply put, you're advised of the charges that are now formally lodged against you. I'm going to advise you of the rights that you have. You plead, after I'm done with that, then you plead guilty or not guilty. After that, sir, the next stage is something called a pre-trial conference. That's where you, if you're representing yourself, or you with your court-appointed attorney, you sit down with the prosecutor and discuss the merits of the case. Okay, sir. So in this matter, you are charged on the complaint of Taylor PD Officer Schillenberg, who states that on March 26th, while in the city of Taylor, that you obstructed the officer from performing his lawful duties, specifically with respect to the stop on where he claims he observed you operating electronic device. Now, a misdemeanor charge in the state of Michigan. It's a criminal offense. It subjects you potentially to be 0 days in jail up to 90 days. Fines could be 0 up to 500. You could be placed on probation also for a period of up to 2 years. Of course, you have the right to have an attorney to represent you. If you can't afford one, one could be appointed. Of course, you start out with the presumption of innocence. You close with that presumption all the way through, unless and until the jury finds out or a judge rules the other way. Now, of course, you have the right to have a trial. The trial could be heard by a jury or a judge. At trial, sir, you and your attorney have the right to cross-examine all of the prosecution's witnesses. You could bring in witnesses that would testify on your behalf, and you could testify or not testify as you see fit. If you choose to remain silent, it can never be held against you. For example, prosecutor could never tell the jury that, oh, you must be guilty because you didn't testify. We don't allow that, sir. The people have to prove you're guilty, your guilt beyond a reasonable doubt. Now, having heard that charge, how do you plead to the charge of obstructing the officer? All right, I'm going to note that the defendant stands mute. Has the same effect, sir, as you pleading not guilty. Now, sir, you are going to have I need you to write this down, please. You will have a pre-trial conference. So where you're going to meet with an attorney here in the court. You need to write this date down, July 16th at 9 a.m. It's an in-person pre-trial conference. Furthermore, sir, we're going to mail a notice of that date to the address that's listed on your ticket. Not going to state the address now because this could go out for further public consumption. Not going to do that. But note, sir, July 16th, 9 a.m. All right. And at this time, I'm going to release you on a personal bond. You don't have to post cash. That's your word that you're going to come back on the July 16th date at 9 a.m. All right, sir. Now, I also want to inform you, we have a couple of other charges. They're called civil infractions. One has to do with no proof of insurance and no registration. Sir, these being civil infractions, they can't be sent to jail for these. They're simply not criminal offenses. All right. You'd be fined up to $100 on each of those, but you can't be sent to jail. Just for your information, they are accompanying charges. So again, sir, today, you've stood mute. I'm going to note you're requesting appointed counsel. I'm also noting for the record, you had spoken with Mr. Kazicki and he's not able to represent you any further. And lastly, again, you're on a personal bond. That's your word that you're going to come back on that July 16th date. Understood, sir?
No, I do not understand.
Pardon me, sir?
No, I do not understand.
Well, I'll explain it again. You come back on July 16th in court for a pre-trial conference. You meet with the attorney who will meet with the prosecutor. That's when they discuss the merits of the case. And right now, I've released you on a personal bond. You don't have to come to the courthouse and post any money. It's your word that you're coming back on that date. I've notified you here on the record of the court date, and further, you'll be mailed a notice.
Yes, Your Honor, I understand that part, but what I don't understand is I don't understand the jurisdiction that the court has over me.
Sir, you're going to be able to discuss that at a later date. This was just to advise you of the charges formally lodged.
Well, I would also like to advise the court that every day that I am in court, I require $1,400, and I will be charging the court $1,400 for my time.
Sir, you can do as you see fit on that count. I'm just apprising you of your court dates. And with that, you're free to leave the meeting, sir. Thank you.
All right, this is 2509380M, the People versus Randall Crane. Are we ready on Randall Crane? Mr. Crane's coming up. Hey, you, Mr. Kazicki?
No.
Mr. Crane, do you have counsel? Was that you, Mr. Barron?
Your Honor, Todd Barrett. I did speak with Mr. Crane prior to the court calling the case today. I think that at this time, Mr. Crane's probably best served proceeding is on his own. There are some constitutional arguments that he's raising that I don't think as a member of the bar I can.
Oh, is he a sovereign citizen?
He's making some sovereign arguments, yes.
Okay, I have very little patience for that. I will let you know that, sir. So, okay, tell me your name.
My name is Randall Crane. That's a living name, not a corporate fiction.
So you're a real person named Randall Crane.
Person. Okay.
Okay, no, listen to me. Sir, you're here today because you have some charges against you. All right.
I'm challenging the court's jurisdiction.
Okay, well, denied. Your motion's denied. I have jurisdiction to the Constitution of the state of Michigan. What's your next? I'm not arguing with you, sir. I have jurisdiction. So
you have to provide subject matter jurisdiction as well as personal jurisdiction to me before these can proceed.
Okay, your motion's denied. I have jurisdiction under the Constitution of the state of Michigan. What else? What else?
You do not have jurisdiction over the national.
I just said I did.
No, you don't.
All right. All right. So, sir, do you want to proceed on these cases and talk to the prosecutor? Don't look on your phone while you're talking to me. If you
my notes are on.
No, you listen to me. If you don't know your sovereign citizen arguments well enough to come up here and say them, I can tell you can't have a court. I can tell you can't have a phone in here. I want you to listen to me. You're here today on misdemeanor charges. No talking. You're brought into court. You've already been arraigned. You have a charge of interfering with police officers in the while they're doing official business. That's a misdemeanor, punishable by up to 90 days in jail and a fine of up to $500. You also have a civil infraction for operating using a mobile electronic device. First offense, while operating a motor vehicle, a charge of no proof of insurance. Those are both civil infractions. Civil infraction for no proof of or no registration in a motor vehicle. So those are the charges against you, sir. I'm going to tell you the rights that are actually real rights that you have in this court. You have a right to an attorney appointed at public expense if you are indigent without money to hire an attorney, and if the offense charge requires a minimum jail sentence or the court determines that it might sentence you to jail. The appointing authority will decide if you are indigent and appoint counsel if you are eligible. You may have to repay the expense for an appointed attorney. You may contest your ability to pay the ordered fees if the court attempts to collect any costs for an attorney, and the court must determine your ability to pay at that time. If you have a trial, you have the following rights. You have a right to, this is how trials work. You have a right to call witnesses to speak for you at trial, and you can get an order signed by the court to require witnesses to come to court. You have a right to see, hear, and question all witnesses against you at trial. You have a right to be a witness for yourself or to remain silent. If you chose not to be a witness on your own behalf, the prosecutor could not comment on your refusal to testify. Lastly, you have a right to be presumed innocent unless you are proven guilty beyond a reasonable doubt. If you enter a plea, obviously you'd be waiving those rights. You also have a right to be released on bond. Now, it looks like you previously stood mute on these charges, so you're here today for a pre-trial. You have a few options, sir, under the law of the United States, the Constitution of the state of Michigan, and statutory law and court rules in the state of Michigan. You can either retain your own attorney to proceed on this case, or you can have a pre-trial with the prosecutor directly and try and work out an agreement, or we can set it for a jury trial. Okay, those are your options. You can get an attorney, use a court appointed attorney, but you understand that attorneys have an obligation to follow the law and not make frivolous arguments, which is what you want to make today. And if an attorney makes those arguments on your behalf, I could sanction them. So no attorney on this green earth is going to come in and make the frivolous arguments you're making on your behalf. Or you can speak to the prosecutor, or we can just set it for a jury trial. Out of those, I don't want to hear it. I want you to pick out of those four options what you want to do. Hire an attorney, speak with court appointed attorney, talk directly to the prosecutor to work towards a resolution, or set a jury trial. Pick.
Let me ask you a question.
No, I asked you a question and I'm telling you to answer it.
And I have the right to understand my rights and understanding.
Sir,
exactly
here,
what.
can you hand him this form? These are your constitutional rights I just read to you. Why don't you have a seat? You have a seat, read your rights, and I'll call your case back up.
I am asking for you.
Have a seat right now and read your rights.
Office.
Have a seat.
Have a seat right now and read your rights, sir. If you don't understand them, read them.
I move for this court to dismiss.
Have a seat.
Okay, next case. All right, we're coming back up. This is 2509380M, the City of Taylor versus Randall Crane. Mr. Crane, you want to come back up? Mr. Crane, did you have a chance to go over your constitutional rights that I provided to you?
Yes, I understand my constitutional rights.
Okay, thank you, sir. So at this time, I gave you four options. Would you like to retain your own attorney? Would you like to speak with House counsel and have an appointed attorney? Would you like to meet directly with the prosecutor? Or would you like to set the matter for jury trial?
I'm going to be requesting for an order of change of venue.
Denied. Anything else? There's no basis for that, sir. So I'm asking you, we'll just set it for a jury trial, okay?
I have to understand everything in regards to my case.
Sir, I gave you your constitutional rights so that you could review them. I also gave you the attorney, court-appointed attorney to go over those rights with. So I gave you an opportunity to understand your rights. I'm not going to entertain, listen, I'm not entertaining your sovereign citizen arguments because they're unfounded and they're not legal. There's no legal basis for them. So I'm not doing it. So now I'm asking you, out of the four choices I gave you, which one would you like to do?
I am required to understand everything in regards to my case,
Okay.
including subject jurisdiction matters.
All right, well, you can do your
personal
research. I'm
jurisdiction.
setting this for a jury trial. We'll see you back for your jury trial on November 14th of 2025 at 9:00 a.m. I really recommend you retain an attorney prior to that date, sir, because I know I'm going to tell you what you're not going to do: waste the citizens of Taylor's time with your nonsensical arguments. You're going to come in, you're going to try your case. Again, if you want to talk to House Counsel, you could do so. All
I'm
right.
not wasting the city of Taylor's time.
Okay, good. We'll
Okay.
see you on your trial date. Have a good day.
I'm gonna just call his case numbers. This is now the matter of the people versus Timothy Tally Williams. This is ticket SP 1283888, count 1, 2, and 3. Ticket SP 1409982, counts 1 and 2. Ticket number SP 1409983, count 1. Ticket SP 1411.
Oh, my bad.
You ready?
Yeah.
Okay. SP 1411848, counts 1, 2, and 3. Ticket SP 1418401, counts 1, 2, and 3. Ticket SP 1466801, count 1, 2, and 3. Ticket SP 1452301, count 1, 2, and 3. Ticket SP 1467130, count 1. Ticket number SX 2454328, counts 1 and 2, and ticket number SP 1283889, expired plates. Appearances for the record, starting with counsel, please.
Judge, this is Attorney Herman Griffin. I did speak with the defendant. I did talk to him, went over his rights. However, he indicated to me that he wants to move forward without the assistance of counsel. So I just want to make sure that's in the record. And I'm going to go talk to Mr. Wallace.
All right. Thank you so much. All right. Is that true, Mr. Williams? You want to move forward without counsel at this time?
Correct.
You know you have the absolute right to have counsel, especially with misdemeanors in these particular matters. But at this point in time, you want to move forward on your own, Mr. Williams?
I do.
Okay. Mr. Williams, how would you like to proceed? Do you want to have a bench trial, a jury trial, or do you want to try and resolve these matters?
I'm trying to resolve them today. And I have a couple of questions before you move forward.
Well, we'll see if I can answer them because I can't give you counsel because I'm not an attorney. I'm not practicing as an attorney. Okay. What's up, Mr. Williams?
All right, but so before you move any further, what jurisdiction is the court under? Is it civil or criminal?
This is traffic kind of acts like a hybrid. So we are it's criminal because it's misdemeanor. So with it carries the underline that you can have like jail time and fines. Usually with civil, it's just going to be fines and it's not going to be the opportunity to have jail time. And that's why you have the ability to be able to have counsel appointed to you because you get the rights kick in, right? You can have a jury trial. You can have a trial by a juror. So we're under the jurisdiction of, I would say, more criminal matters for these.
Okay, so in the Constitution grants 2 jurisdictions. That's one under the common law and the other under Constitution under the condition of contract criminal aspects of a colorable amnesty jurisdiction.
So this is under the misdemeanor state ordinances as well as was not state ordinances, the misdemeanor crimes under the state law, as well as under the city ordinance violations that these fall under. So each city is, in order to govern itself, you have the absolute power of the United States of America. After you have the absolute power of the United States of America, what they've done is they've divvied up the opportunity for states to control their own entities as long as they don't interfere with the federal stuff. So they can be more stringent than the federal laws, but they can't be any less stringent than the federal laws. And the same trickles down in the state. So then you have the state government and then you have city government laws, which allow the opportunity for them to create ordinances and rules to be followed by those individual states. So that's how we kind of operate. And so we are able to function and operate as a city if you avail yourself to the operations of a city or a state.
I didn't get that.
I know. So we're operating under the state law, city ordinances, and state ordinance by state misdemeanor violations.
So it's colorable admiralty jurisdiction through contracts.
So that's archaic law, and what I mean by that is that that's although we use those terms, those Latin derivatives during law school, the actual practice is known as state has the ability to govern its people, and the city has further governance over its people to be able to make sure that rule and order is continued and followed within the state guidelines. All right, Mr. Williams, what do you want to do, though? Because we're not going to have a question and answer service. I've been on the docket for a while. If you do want to, you can come back at 1:30, and I'll be more than happy to continue this educational opportunity.
But no, I want a motion to dismiss for failure to...
Okay. All right. So that's not going to be granted, and that's not the correct order to do it. So if you wanted to file something like this, you could be able to file it and make the legal arguments appropriate for these matters, but you would have to state some type of legal reasoning as to why. And jurisdiction is not a legal reason. Well, it's a legal reasoning, but you can write that and see how you can find the laws that are current to our state constitution, as well as the constitution of the city of Detroit, and the rules and opportunities to be able to follow that. So if you would like to file a motion, you can have a motion date and time to be able to file that. I'm not going to dismiss them today, though.
So why can't I get dismissed today?
Because these are ordinances that you are to follow within the city. There are rules that we follow as human beings in the United States of America, especially under the city of, you are a resident of the state of Michigan and the city of Detroit.
But under what contract? Under common law or?
It's not a contract. You know, these are not contracts. Okay. So these are just regular rules. So you listen, Mr. Williams, you can either handle these matters or they'll just go back into default and be in default, as well as they'll be under warrant status. Listen, I know you are trying to handle them, but you want them dismissed. They are rules that you have to follow as a citizen of the United States of America, more importantly, as the state of Michigan, and as someone who traveled, moved about in the city of Detroit. These are the rules that have been established for reasons. And sometimes their underlying reasons are reasons that we all can see and understand clearly. Sometimes the reasons are not reasons that we really understand, but these are the rules that have been set into place. We have jurisdiction because you are a body, a person, an entity, a being that is located within the confines of the state of Michigan as of right now, who has done stuff within the state of Michigan in the city of Detroit. And that's why we have the opportunity to be able to do these things. All right. So well, Attorney Griffin, all right. All right. I can't, Mr. Williams. I can't argue back and forth today with you. I've had an amazingly long docket this morning. So I told you, you can come back and we can have this discussion at 1:30, but I need to finish the rest of the people from this morning's docket before I continue to have these discussions. So I don't mind. We can do it at 1:30, but I got to finish my morning docket before we have all these philosophical discussions on why I have jurisdiction over you as a court. Okay. I told you, Mr. Williams, to come back at 1:30. My staff needs a break and I need a break as well.
Can I come in, or I gotta do the video?
You can do video. You want to have an in-court? Listen, if you want to have an in-court discussion about all of this, I want written, filed motions for all of this. I'm not going to have a philosophy discussion about why we have jurisdiction over you. So you need to file motions, the appropriate motions with the court that go with each one of the things that you're talking about that you want to happen. I'm going to repeat, I'm not going to dismiss them because you think I don't have jurisdiction. I'm not. But you have to show me why we don't have jurisdiction over you.
But Your Honor, you're supposed to be an unbiased arbiter. We're supposed to be in between.
That's right.
The prosecutor.
That's right.
The prosecutor needs to explain how she got jurisdiction over me.
So you have, and their explanation comes when you file a motion. So you need to file a motion so that they can know what legal principles and arguments you're standing on so that they can properly respond to it. If you just say that you don't have jurisdiction, I'm going to tell them that as an officer of the court, we take judicial notice that if you were in the city of Detroit operating or doing any of these things, that's why they drew the ticket on you. But if there's a jurisdictional issue, you have to state a legal reasoning why and give the prosecutor's office time to respond to your legal, factual basis and reasoning as to why that happens. So I'm more than welcome. I'll set a hearing date to give you motion times to be able to do that, but you have to file a written motion as to why you believe legally they don't have jurisdiction over you.
But ain't that state duty? That's the reason why I'm here.
Duty of it. So I'm telling you, I take judicial notice that the ticket was written in the city of Detroit. So they have a legal reason and basis for giving you the ticket. You hear that? That's the first thing. So right. I'm already stating as an officer of the court that by receiving these tickets, they have a legal reason and jurisdiction over you. Right? But if you believe they don't.
If you run my name, you will see that I surrendered my state ID and I have a passport, right? I have no contracts with the Secretary of State whatsoever. So
you just have the United States of America, which is an even higher jurisdiction than us.
Right. You know what I'm saying?
Right.
Right. So the SOS, I don't have no contracts with them. And if you run it,
just because you don't avail yourself of the formal process doesn't mean that you cannot be held to the standards and rules of the Secretary of State's office. That's not how this works. So you don't sever ties. That's not how it works. If you avail yourself to the rules, if you allow yourself to get into a vehicle and drive on the streets in the state of Michigan, in the city of Detroit, you have now automatically availed yourself to the laws, to the civil infractions, to the misdemeanors which lie within this state and the city bounds.
That's not what the Constitution says. And you took an oath.
I did. Right. I took lots of oaths too, just so you know. Mm-hmm. I done took all kinds of oaths to be an attorney, to be a judge, to be, when I graduated from college, I'm sure I took some oaths. I've taken oaths. And that's why I can say with a straight face and a clear conscience that I am following the rules of the state of Michigan and the city of Detroit when I say that they have the ability and the right to write tickets to people who travel, go upon the city streets of the city of Detroit, the state of Michigan, and to issue tickets to individuals. We deputize those individuals on the street. Now, whether or not it's true, that's another type of hearing. Whether or not these allegations are that have been alleged are true, that's not the hearing that I'm deciding today. Unless you want to take some type of offer. The only thing I'm deciding today is whether or not you want to move forward with some type of plea, or whether or not you want to move forward with a trial, or whether or not you want to move forward in that type of capacity and way. So, and you said that you don't believe that we have jurisdiction or that these tickets are not. So I'm telling you, if you don't believe it's jurisdiction, you have to file a written legal document that says why you don't believe that they have jurisdiction. And so that they can respond to it legally, like on a legal basis.
I'll do that.
Okay, so how much time do you need, Mr. Williams, to have the hearing? Because what they do is you'll submit your written stuff. They'll get time to be able to respond, and then you'll have a copy of that so that you can make sure that you can understand what's going on. So how much time do you need?
Give me to January.
Okay. January? So we'll come back on January 30th. That gives you 90 days. I need the motion filed before then, though. So I need the motion filed by January. On the record, recalling the matter of the people versus Timothy Williams and all his matters. Can I have your name for the record, sir?
Timothy Williams.
All right. And then, City, I'll make sure that also the attorney that's typically assigned knows this as well. I'll set it that it be, I'm trying to find a calendar for January, sorry. I don't know if it's on there. Okay. All right. So I'm going to have a hearing in this matter. Let's do it on a Thursday. So let's do it February 1st because I'm going to need time. February 1st, 2024 is going to be the actual hearing date though, but I'm going to have you submit your motion no later than January the 12th. And then there needs to be a response from the people by January 26th. And we'll have the motion hearing on February the 1st.
Okay, Your Honor, I'm sorry. I was in another courtroom. This is the prosecutor, Dia Chiku Mason. So we're doing on Mr. Williams, Timothy Williams.
So he wants to file a motion. I told him if he wants to file a motion, it needs to be filed no later than January 12th. The people have the response needs to be by January 26th. And the hearing will be February 1st.
Very good, Your Honor. Thank you.
Okay, you're welcome. All right, there's nothing further. That concludes this hearing for today.
Your Honor, am I able to come in or is it going to be?
Are you what?
Am I able to come in on this?
You can physically come in if you want to. You want to have it in person?
Yep.
Okay, in person on February the 1st, 2024, okay?
Yep.
All right. All right, that concludes this hearing. Bond will continue at $0 personal.
Thank you.
I'm not threatening you. Say one more word and that's 30 days. 30 days.